Thank you very much, President Robinson, and thank you also for the extra time that you allow me to use. And so I'm not going to read just alternate lines, but well, first of all, I would like to stress the fact that I've been invited as a professor of comparative and international criminal law, and this would be enough to recall Nino Cassese as a maestro, as a mentor, as an example for my generation in particular. But I'm not only a passionate scientific reader of Nino's work, I was also a colleague of Nino at the University of Florence, and at different times, Dean of the Law School and Vice Rector of the University. So in some way, I represent, well, not so much the institution, I would say, but a large and transversal community of about 60,000 people, professors, students, administrative staff. And it's on behalf of that community that I would like, to publicly express our gratitude and pride for having had such a wonderful person with us, and we will miss him a lot, really. Now, coming to the topics that we are discussing here today, I would like to comment on, from the particular perspective of my background. Before getting involved with international criminal law, I was, and I basically remain, a criminal law and criminal procedure professor with a strong comparative law propension. So, my first point would be to say that I totally subscribe to President Robinson's suggestion that there is no fundamental principle of law that requires ICTY to work both in civil law and common law systems. I also agree that it is irrelevant whether the tribunal is a civil law or a common law system. Even more radically, I think that we should restrain from referring so much to these two models, the common law and the civil, as useful tools to understand, develop, reform criminal procedure today. In general, reference to these two models is most of the time misleading and non-informative. Reforms inspired by the models approach ended up producing most of the time unintended results, and very often results which are very different from what reformers had in mind. So my point is that the models approach produces poor architecture and poor interior designs, so to say. One example is plea bargaining. I think that's a very good example. Since one can never tell whether introducing some form of plea bargaining will be well received in the system or almost ignored. And we don't really know what makes working plea bargaining. And I think, for example, that the structure, size, and work organization of law firms is a very important factor, but has not very much to do with the models. Also, in recent history, we've been watching transformation of criminal procedure everywhere. Almost everybody is claiming to be going towards the adversarial Anglo-American model. Even France, the homeland of juge d'instruction, wants to get rid of the investigating judge. So, however, everybody is going its own way, and the result is a great number of national variations. But even more than this, I think, even besides this, I think that when we deal with international criminal law, we should not forget the achievements and the awareness that we developed in domestic criminal law and procedure, thanks to critical legal thinking, to the reaction against the excesses of formalism, the excessive positivism, and thanks to sociology, thanks to legal anthropology. We should not forget the lessons of legal history that tells us that the law is much more experience than written rules and logic. So the point is that domestic criminal justice and criminal procedure is heavily based, so to say, on closure. So we see only a small portion of the mechanism. a large part of the machinery is hidden in some way, and we can only guess about how it is. So codes of procedure also, they spell out, so to say, the essential play script of a much more elaborated drama. And the drama, the action of the criminal proceeding, takes place in the real world, in the real society, with many more actors. And the performance of these actors is heavily affected by a number of factors, legal factors, but very often factual, political, sociological. And this is why the shape of each legal system is really unique. So the real challenge today, I think we should not forget that, is to try to understand how each system actually really works, which forces and factors drive the system, where is discretion, how is controlled, to what extent the criminal procedure is affected by its social functions. So I think that this makes really difficult to borrow, single rules, specific rules from one system to the other, and even more difficult to bring these rules and mechanisms into the international criminal law setting. In fact, when we are borrowing rules from a model, we are not really using a model, but we are referring to a given historical experience, and we can now borrow all factors that make the rule and the legal mechanism working in that way in that system. So I think that for all these reasons, it's much better to develop international criminal procedure as something driven by, first of all, its own political foundation, its own policies, its own principles of efficacy and fairness. Abstract stereotypes are useless. What can we say about these distinctions, common law, similar law? Is there anything that can be still kind of useful? Well, I think one issue is to keep in mind the mentality of the people that come from one experience or the other, but not so much. It's more important, I think, legal education that they received in the two different settings than the experience in the criminal procedure itself. And also the awareness of certain connections between segments of the procedure. For example, we know that some rules of evidence depend on the presence of the jury, and we have to keep that in mind. We know that some powers of the judges depends on the knowledge of the dossier. And so when we don't have that connection, we should maybe wonder, well, will it work? We also should keep in mind that some features, for example, the standard of evidence, depends also on the bifurcation between adjudication and sentencing. And we know that that link exists, and we should keep in mind that that might be relevant.